This exam develops your knowledge and skills in understanding of the general legal framework of specific legal areas relating to business, and your ability to recognise scenarios where it is necessary to seek further specialist legal advice. accaA recommends studying with an approved learning partner and using study materials from our approved content providers. However you study, accaA will support your learning journey with a range of free resources. There's study guidance to help you get started, and support throughout your learning journey to get you exam ready. There is guidance from the examining team, including examiners' reports, which provide constructive and detailed feedback, and there are technical articles, exam technique guidance, as well as videos and webinars to support your studies. This is a 2-hour exam and is divided into 2 sections. Section A is worth 70 marks. It contains 21 mark questions and 25 2-mark questions. The whole syllabus is open to be examined, so it's important to prepare thoroughly. Section B contains 5 6-mark multitask questions. They concentrate on analysis and application of learning. The questions are presented as problem scenarios and contain a series of tasks. Using the resources available from accaA and your approved learning partner is the proven route to exam success. So good luck with your corporate and business law exam from everyone at accaA.
Jo's contract of employment states that she is employed in Glasgow. When her employer tells her that she has to work in London, some 500 miles away, Jo immediately resigns. So let's just be clear on what's happening here. Jo's place of employment, which is Glasgow, is in her contract of employment. And therefore, when her employer tells her that she's having to work in London, London is not nearby, it's 500 miles away. So this constitutes a change in the contractual terms. Now, Jo immediately resigns. Which of the following may this be considered an example of? What sort of dismissal? Well, the first thing to note is that the employer has not directly actioned the dismissal. As a result of that, we can eliminate 2 of these options. Unfair dismissal is when an employer dismisses an employee for an unfair reason. And that could include things like dismissal for pregnancy, maternity, jury service. Those are examples of things that would be automatically unfair reasons for dismissal. But that's obviously not happened here. Summary dismissal is when an employer dismisses an employee without notice for a serious breach of contract. So, for example, gross professional misconduct could result in summary dismissal. The employee is dismissed without notice because what they have done is so serious, so bad, there is no reasonable grounds to give notice. So again, that hasn't happened here. That leaves us with constructive dismissal. There are 2 dimensions to constructive dismissal. Firstly, that the employer commits a serious breach of contract, and secondly, that the employee leaves as a result of the contract. So, did the employer commit a serious breach of contract? Well, moving your place of employment 500 miles would reasonably be described as a serious breach of contract. Did the employee leave as a result of the breach? The key word here is immediately. In other words, if Jo had continued to work for a number of weeks and then resigned, that would not be constructive dismissal. The situation here, we can see she has clearly left as a result of the breach. Therefore, we would be looking here at constructive dismissal. B injured her eye after failing to close a safety gate on a machine as instructed. She was also not wearing mandatory safety goggles as required by her contract of employment. Which of the following is this an example of? So B has been injured. When we look at what caused the injury was caused by B failing to follow her instructions. So she failed to close the safety gate on the machine as she had been instructed. She failed to wear the safety goggles as required by her contract of employment. So what is this an example of? Well, contributory negligence. This is when the defendant's liability is reduced due to the claimant's behaviour. Well, in this situation, the defendant, the employer, has no apparent liability. So the employer has provided instructions, they've provided safety goggles, they've included all of this in the contract of employment. So there isn't really a liability to reduce. On the other hand, the valenti non fit injuria translates roughly as to a willing person, no injury is done. In other words, what's happened here is B has failed to close the safety gate. She's failed to follow the instructions on the safety gate. She's failed to wear the goggles. And the courts would say, well, that action, those behaviours, effectively you have consented to the risk that you are exposing yourself to. And therefore, we would see this as valenti non fit injuria. Now, just to cover the other two options, just to demonstrate why they are incorrect, novus actus interveniens, a new action intervenes. So this would be the case if something happened between the defendant's negligence initially and something else happening which fundamentally changes the situation that could not have been reasonably foreseen. That's not the case here. And then finally, res ipsa loquitur, the facts speak for themselves. This is used to reverse the burden of proof. So in some situations, the negligence is so obvious, there is no other logical explanation for how this situation may have arisen other than negligence, and therefore the burden of proof is shifted onto the defendant to show that they are not liable. So, for example, if you went in for an operation and you woke up and a week later you were really, really ill, and it was discovered that various large medical implements had been left in your body after the operation, that would be an example of res ipsa loquitur. It would be very difficult to explain how on earth those medical instruments got into your body other than through the operation. And it would be very difficult to explain how those could have been left in your body without somebody having been negligent. Now, none of that is the case here because the defendant in this case has not done anything that is obviously negligent. So therefore, what we've got here is B has effectively consented to an injury, valenti non fit injuria. In the context of case law, which of the following applies to an obiter dictum? Well, obiter dictum means a statement made by the way, as an aside. So it is a fact, it is part of the case, but it is not the basis on which the decision has been made. So, for example, in the famous case of Donahue and Stevenson, the snail was found in a ginger beer bottle. Now, the fact that the bottle contained ginger beer was a fact. but that fact, the ginger beer, is obiter dictum. It's by the way. It could have been any drink, and it would be misleading for any court to interpret that fact that it was ginger beer differently if it was a different drink. And therefore, if a statement or a fact is made by the way as an aside, it is not binding on any courts. It is not relevant to the decision that has been made. Now, we can differentiate between obiter dictum and ratio decidendi. And ratio decidendi means the facts that are binding, the heart of the case, the legal issue that is then binding on other courts. There are a number of ways in which investors can take an interest in a company, and such different interests have different rights attached to them. So which of the following normally participate in surplus capital? Now, the word normally is relevant here because there can be exceptions, but those exceptions have to be implemented in a very specific way. So in a normal situation, who participates in surplus capital? Well, just as a reminder, surplus capital is remaining after all debts have been paid. So in this situation, a debenture holder is a debt holder. So whether that debenture, whether that loan is secured by a floating or a fixed charge, they would not participate in the surplus capital. They would only reclaim the debt that they are owed, and then everything would stop. So we know it can't be a debenture holder. We're now left with ordinary shares or preference shares. Now again, the word normally here, normally preference shareholders have a fixed pre-agreed return. So although they are repaid ahead of ordinary shareholders, the return that they get is limited. They would not normally participate in surplus capital once their fixed rate has been paid. The investor who does get to participate in the surplus capital is the ordinary shareholder. And the ordinary shareholder is the person who invests their money. They are the most exposed to risk, and therefore they have the most opportunity for reward by being able to claim that surplus capital. Anne got trapped in a public toilet due to the lock being faulty. Rather than wait for help, she tried to climb out of the window but fell and broke her leg. Which of the following is this an example of? So let's look at the situation. Anne got trapped in a public toilet due to the lock being faulty. So that suggests negligence on the part of the maintainers, the people responsible for the public toilet. So at this point it looks like, yes, there has been some negligence. However, rather than wait for help, Anne tried to climb out of the window but fell and broke her leg. So the question is, why did Anne try to climb out of the window? It wasn't that the building was on fire. She wasn't in any immediate danger. She just simply didn't want to wait for help. In doing so, she fell and broke her leg. Now, the action that she's taken, trying to climb out of the window, she is not consenting to the injury. In other words, what she's doing is not so extreme as to consent to the injury. So this is not a case of volenti non fit injuria. To a willing person, no injury is done. In addition, the action that she's taken in climbing out of the window is not completely unforeseeable in the circumstances. And therefore, this is not a novus actus interveniens. If, for example, Anne had decided to start setting fire to the toilet paper while she was waiting, I think we would say that is a novus actus interveniens. That's not reasonably foreseeable. But the idea of somebody wanting to get out if they're locked in, that is not outrageous. Finally then, res ipsa loquitur, the facts speak for themselves. This is used when the defendant's actions have been blatantly, obviously negligent. And we have not got that here. A faulty lock can arise for all sorts of reasons. It's entirely reasonable to give the defendant an opportunity to explain why the faulty lock was not negligent on their part. That leaves us then with contributory negligence. In this case, the defendant's liability, whoever's responsible for the public toilet, their liability is reduced but not excused due to the claimant's behaviour. So Anne shouldn't have tried to climb out of the window. That wasn't a reasonable, sensible thing to do. So the liability is reduced, but that doesn't stop the defendant being liable for the lock being faulty in the first place. So the answer here is contributory negligence. This question gets to the heart of the difference between an employee and a self-employed person. And this has a number of quite important implications, both for legal and tax purposes. And so what the courts do is they use a multiple test. And there's a handy mnemonic that you can remind yourself about these multiple tests, and that's MICE. M-I-C-E. So is there mutuality of intention? In other words, the intention of the employer to provide the work and the employee to do the work. To what extent is the individual's work integrated into the company as a whole? To what extent can the employer control how the worker performs their duties? And what is the economic reality? So does the individual doing the work have a number of different people they work for? Can they delegate the work to other people? So on that basis, we know that the control test, the integration test and the economic reality test, those are all parts of the multiple test for establishing an employment relationship. The only one that isn't, and therefore the one that we need to select, is the subordinate test. The subordinate test looking at the extent to which the individual has to subordinate themselves to the person giving the instructions. And the courts would say, well, whether you are self-employed or employed, that subordination is likely to exist in the relationship. So, Mark is receiving an agenda for the AGM of this company he has shares in. Now, there are a number of resolutions to be proposed at the meeting, but Mark is not certain as to what exactly is involved. So, In the context of company meetings, which of the following must be passed by a 75% majority to be effective? Well, our first option here is a special resolution. A special resolution needs 75% or more majority to be passed, so that is the correct answer. Just to eliminate the other ones, an ordinary resolution with special notice. So an ordinary resolution requires a greater than 50% majority. So 50% is not enough to pass an ordinary resolution. You need more than 50%. When there is special notice, it is the notice that is special and not the resolution. So it doesn't change the fact that you still only need over 50%. Now, a written resolution could have either over 50% or a 75%, depending on the nature of the resolution. However, the key to this is it is a written resolution. In other words, it's done in lieu of a meeting. The question specifically refers to the context of company meetings. And it says which must be passed by a 75% majority. So because a written resolution does not take place in a company meeting and does not always have to be passed by 75%, that can't be the answer. The answer here is definitely a special resolution. Section 122 of the Insolvency Act 1986 provides a number of distinct grounds for applying to have a company wound up on a compulsory basis. Which of the following is not a ground for the compulsory winding up of a company under that provision? So we're talking here about an application to the courts to force the company to be wound up. So this is a compulsory winding up. Now, this is in statute, it's in law, so in terms of the answer to this, if a company alters its primary business within the first 12 months, that is not grounds for applying for a compulsory winding up, because what the company has done, it has altered rather than ceased trade. Now, it might be that parties, shareholders, stakeholders don't like that. Well, there are other avenues that they can take to take action, but they cannot take action in terms of forcing a compulsory winding up. The other ones, though, these are valid grounds. They have not received a trading certificate, so they are basically trading without a trading certificate. You can apply for compulsory winding up for that. And if you have either suspended or not started trading for 12 months, again, that is grounds to apply to have the company wound up on the basis that you're saying, well, look, basically, we haven't been doing anything for the whole 12 months. There's no point in keeping the business going. We need to wind it up. So those three are all covered under the Insolvency Act 86. It's only the first one, altering the primary business, that is not. Abe has issued an invitation to tender for a contract and B has submitted her terms. Which of the following statements is correct? Well, Abe has issued an invitation to tender. The key word here is an invitation. In other words, this is not an offer. Now, once we've established that this is not an offer, we can eliminate two of the options. So it can't be option 1 and it can't be option 4. So the only question now is, what is B's action when she submits her terms? Is that an offer or an invitation to treat? Well, the key question when B submits her terms is, can they be accepted without further discussion? So B submits her terms. Can Abe then say, I accept, and everybody's clear where they stand? If they can, then that is an offer. If there's still discussions to be had, then it's only an invitation to treat. The fact that these are terms in response to a tender means that this is going to be seen as an offer. So the answer is the third option. Abe made an invitation to treat and B made an offer. This question looks at statutory interpretation and gives us three of the tools of statutory interpretation. So the first of these is the literal rule, where we simply give the words their ordinary dictionary meaning. So we read the statute, we interpret it, each word as you would in any other context. Now that does create a bit of a problem, and the problem is illustrated by the golden rule. And the intention here is to avoid absurdity when giving words their ordinary meaning. And the case of Crown and Allen is a great example of this. Now, in this case, Mr. Allen was accused of bigamy. And the statute said that whoever is already married and marries another commits bigamy. And Mr. Allen's defence was, well, actually, yes, I was already married, so yes, that was true. But because I was already married, when I went with this second person and went to church and did all that, I didn't actually marry them. The marriage wasn't valid. And therefore, the defence was, well, I haven't breached the law because I didn't marry somebody else. I would have been married if I wasn't married already. And of course, the courts then said, well, that's absurd. Because if you interpreted the words on that definition, nobody would ever be able to commit bigamy. What the court said was, the word marries in that context means goes through a marriage ceremony rather than being legally married. So that's the golden rule that allows us to avoid any absurdity here. Now, the third area here, the mischief rule, it asks, what is the mischief? What is the intention that the statute is intended to address? And therefore, in the context of this question, which of the following requires judges to consider the wrong which the legislation was intended to prevent? It is the mischief, the underlying intention. Now that gives judges quite a lot of scope, because it allows them to go certainly beyond the literal, even beyond the golden rule, to ask what is it they're trying to do, and therefore allows them to apply legislation in a much wider context. This question looks at consideration, which is one of the criteria that we need for a valid contract to exist. So remember, for a contract to exist, you need offer and acceptance, you need consideration, and you need intention to create legal relations. And in this context then, consideration is something of value that each party brings to the contract. So person A has to hand something over to person B and vice versa. Now, in terms of the legal definition, this is one of those classic legal definitions that you need to be aware of. The answer here is it must be sufficient, but it need not be adequate. And so what the courts mean by this is when we talk about it being sufficient, there must be some value in what is being transferred. However, it does not have to be adequate. It doesn't have to be a reasonable value. So, for example, there was a case with the Nestle chocolate company where it was deemed that handing over chocolate wrappers in return for a gift, or well, it wasn't a gift, it was a product that was being handed over. The court said that was sufficient. It wasn't adequate. In other words, the value of the chocolate wrappers was minimal. You know, it's a fraction of a penny's worth, but there was some value recognised in it. So there we go for consideration. It must be sufficient. It need not be adequate. Dan has been accused of a criminal offence and is due to be tried soon. Now, he denies responsibility, claiming that the prosecution has no evidence that he committed the offence in question. Which of the following describes the standard of proof in a criminal case? Well, let's just remind ourselves, a criminal offence is a case where the individual is prosecuted by the state and the intention behind it is to punish a wrongdoer. So Dan has been accused of a criminal act. The question is, has he done this? Should he be punished? Now, the standard of proof in a criminal case is higher than in a civil case. So a civil case, the defendant is sued by the claimant, the person injured, and the objective is to provide compensation. Now, in terms of the burden of proof, in a criminal case, because the individual is being punished, the burden of proof is very high. It is beyond reasonable doubt. So obviously, we can never be 100% convinced of somebody's guilt. You know, they could be standing there with a knife covered in blood, screaming that I killed the person, you know, with DNA evidence all over the place. But, you know, maybe it was that person's long lost twin brother who's got the same DNA. You know, there's always some really obscure possibility they might be wrong. So beyond reasonable doubt, in as far as anyone can ever be certain about anything, are we certain that this person committed the crime? So the answer here is beyond reasonable doubt. And just for the record, if this was a civil case, the burden of proof is lower. It's only the balance of probability. In other words, it's more likely that I've caused damage to the claimant than that I didn't. Okay. But for criminal cases, a very high burden of proof that's placed on the prosecution. Remember, of course, that you are innocent until proven guilty. This question looks at the liability of shareholders in the case where a company is being liquidated. So the scenario here, Ho subscribed for some partly paid up shares in IO Limited. So if they are partly paid up, what that means is Ho has contracted for the shares, so the contract has gone through, but the full payment for the shares has not yet gone through. So Ho owns the shares, still owes some money. Now the company has not been successful, and Ho has been told that when Lo is liquidated, he will have to pay the amount remaining unpaid on his shares. He's not sure who the payment should be made to. So we've got here a limited liability company. Who is the shareholder liable to? Now, we need to be very clear about whose relationships are with whom. Now, with a limited company, the contractual relationship is between the company and its creditors. So we talk about the veil of incorporation that protects the shareholder. So in the event of the company being wound up, the creditors cannot go directly to the shareholders in order to get the debts paid. That route is blocked off to them, with some exceptions, but generally speaking, that's what limited liability is. It limits the liability of the shareholders. Now, this is a slightly different situation because we have here Ho, who is the shareholder. Now, Ho owes money to the company, and he owes money for the shares that he has been handed, that have been handed over to him, that he now owns, that he hasn't fully paid for. So when the company is liquidated, that transaction needs to take place. Ho needs to hand over the money that he owes to the company. And then, of course, what the company can then do, or in this case, the liquidator of the company, can then distribute that money to creditors. Therefore, shareholders are liable to the company for any unpaid capital. That's who their contract is with. The fact that that money might then be transferred to somebody else is not the point. The contract is with the company, so that is whom they are liable to. This question asks about the recognised phases in money laundering. Now, in the syllabus, there are 3 recognised phases. Phase 1 is the placement, where the proceeds from some criminal, some illegal activity is deposited into an apparently legal business or property. Stage 2 is layering. And what happens at this point is the money is transferred from account to account, from business to business. And the objective here is to try and hide that initial placement, that initial deposit. And stage 3 is integration. And the idea is that having transferred the money through so many different accounts, in stage 2, it now appears as if that money has come from a valid, authorised, legal source. So the true source from stage 1 is no longer visible because of all the layering. It has been integrated into the financial system. So therefore, in terms of the recognised phases are layering and integration. Those are the specific pieces of terminology that you would be expected to use in the exam. This question is all about insider dealing, which is regulated by the Criminal Justice Act 1993. And in that there are a number of specific offences. Now these are offences specifically in relation to insider dealing. So the first is passing on inside information. So inside information is any price sensitive information. So passing on that information, even though there's not a demonstrable link to using that information or the other person using that information, the fact that you are passing on that inside information is a crime. The other crime in the Criminal Justice Act is encouraging someone to engage in insider dealing. Interestingly, the offence here is the encouragement, regardless of whether the person actually follows through. So the offence is me trying to persuade somebody to engage in insider dealing. Even if that person doesn't go on to do it, I have still committed an offence. So those two are specific criminal offences relating to insider dealing. With regards to concealing insider dealing or failing to report it, those are not specific to the Criminal Justice Act 1993. There may be issues of liability, as you would get with any criminal offence, sort of obstructing the police in their inquiries, failing to report an offence, that sort of thing. But it's not specific to insider dealing in the way that passing on inside information and encouraging someone else to engage in insider dealing would be. The third crime, which we haven't listed explicitly, but just for the sake of completeness, the third crime under the Criminal Justice Act is to deal in listed securities if I am in possession of price-sensitive inside information. Okay. So those are your three criteria, your three offences under the Criminal Justice Act for insider dealing. This question looks at contract law and specifically offer and acceptance. So remember, when we talk about acceptance, we're talking about an unequivocal assent to all of the terms in the offer. In other words, if somebody can say, I accept, and both parties are completely clear and completely happy, that's fine. If the person's saying, I accept, but could you just explain, or could you just clarify, or I'm not sure about this, that and the other, that's not an acceptance. So with that in mind, which of the following can be accepted? Well, the quotation of a price can be accepted. So if somebody says, I'm selling my car, you've asked me for a quote, I'll sell it to you for £100. You can say, yes, I agree, and the transaction takes place. A statement of intent is about a possible future intention. It's not specific enough to accept. It's what I would like to do. Yeah, I've got an intention, but just because I intend to do something doesn't mean it's automatically going to follow through. Now, interestingly, an agreement to enter into a future contract, whilst that might be binding, the key here is that it is in the future and not current or present. So if somebody says, listen, I undertake to enter into a contract with you in 1 year's time, I can't turn around to that person and say, I accept the contract now exists, because it doesn't. It won't exist for another year. And the supply of information is not specific enough to be accepted. All I'm doing is simply giving somebody information. For example, I might send them information about my products, the range that I offer, where I make them, all of that sort of thing. Well, that's giving them information, but that's not an offer that can be accepted. So the only one of these that can be accepted as an unequivocal assent is the quotation of a price. This section B question is all about breach of contract and remedies. So we've got here AZ Limited operates a shipbuilding business which specialises in constructing and modifying ships to order. So these are bespoke pieces of work. In 2011, they entered into an agreement with Bob to completely rebuild a ship for a price of £7 million. Now, the problem is, once the work was done, Bob informs AZ that he no longer needed the ship. So Bob doesn't want to pay, doesn't want the ship anymore. AZ had already spent £5 million on altering the ship, so that's its costs. And so they're now starting an action against Bob for breach of contract. Now, just before the case was due to be decided, AZ sold the ship for the same amount of money that they would have received from Bob. So we've now got 3 questions to consider here. Task 1 asks you which 2 of the following statements explain the purposes of awarding damages for breach of contract. Well, let's be clear on this. The action that is being taken for breach of contract is a civil case. And the role of a civil case is to compensate somebody who has suffered loss. And we contrast that with the criminal case, which is there to punish the wrongdoer. So which 2 of the following statements are relevant here in terms of damages for breach of contract? So the first thing that these damages do is they compensate the injured party for their financial loss. So it's recognising financial loss. Of course, financial loss, the reason that that's focused on is because it can be quantified. And you may remember from some of your other studies or research that actually when you start trying to compensate people for things like loss of enjoyment, it very quickly becomes very messy. So as a general rule, damages are there to compensate specifically for financial loss. And the key to this as well is that they are designed to put the parties in the position they would have been in had the contract been performed. Now that is very different to putting people back in the position they were in before the contract was formed. So here's a practical piece of advice for you. If you ever buy something from a shop and it causes you problems, you know, it's not working or whatever, and you go back and the person behind the counter says, well, I'll give you a refund. Well, you have the right to accept that refund, but you also have the right to be put in the position you would have been in had the contract been performed. In other words, to get a replacement product, a reasonable replacement. We've established that because this is a civil and not a criminal case, we are not looking to punish the party. Now, there are some legislative areas, for example, in the United States, there is this concept of punitive damages, where the wrongdoer, the person who has breached, is punished in order to deter other people from committing a similar breach. Now, that is not consistent with the English legal system. It happens in very, very rare exceptions, But generally the objective with any civil case, and specifically here with contract law, is we put the parties in the position they would have been in had the contract been performed, and we make up for any financial loss that they've incurred that hasn't got them to that position. Task 2 asks which two of the following statements in relation to the duty to mitigate losses are correct. Well, the person who has suffered the loss is the claimant. And in terms of mitigating that loss, reducing that loss, therefore it is the claimant, the party who suffers the breach, that would look to mitigate their losses. What does that do? It will therefore reduce the damages that are payable. So this whole idea of mitigated losses is to get away from a situation where a claimant has a valid case, but then deliberately manufactures a situation where the losses pile up. So claimants have a duty to reasonably mitigate their losses. The third and final task for this question: what level of damages can AZ claim for breach of contract? Well, remember from task 1, we said that they can claim for their actual financial loss. So if the contract had been properly performed, they would have received £7 million from Bob. Now, Bob didn't pay them £7 million. They took legal action. However, what's now happened just before the case is due to be decided, then they've sold the ship for the same amount of money that they would have received from Bob. In other words, they've received £7 million, but from someone else. Therefore, AZ has actually made no loss. The only difference here is that they sold the ship to somebody other than Bob. But in terms of the cash flows, they've received exactly the same cash flows. Therefore, their financial losses are nil. And so if this case did go to court, chances are that Bob would be found liable for breach of contract, and the damages would probably be nominal damages of £1. In other words, recognition that yes, you were in breach of contract, but in terms of the loss suffered, it is non-existent. This question is all about partnerships. And the golden rule with partners in a partnership is that they are jointly and severally liable. So as partners, they all share the responsibilities. So let's look at this. Claire, Dan and Eve, C, D and E, formed a partnership 10 years ago. Now, Claire was a sleeping partner, never had anything to do with running the business. Last year, Dan retired from the partnership, and Eve has subsequently entered into 2 large contracts. The first one was with a long-standing customer, Greg, who had dealt with the partnership for 5 years. The second was with a new customer, Hugh. Now, both believed that Dan was still a partner in the business. Both contracts have gone wrong, leaving the partnership owing £50,000 to both Greg and Hugh. Unfortunately, the business assets will only cover the first £50,000 of the debt. So there is a shortfall to cover. And that shortfall, the question then arises, who is liable? We've got Claire and Dan and Eve. Now, we've said that the initial starting point is that partners are jointly and severally liable, but there's a couple of strange things here. So Claire is a sleeping partner and Dan has retired. So that's going to make it a little bit more complicated to think through. Well, for task 1, Claire as a sleeping partner still has full liability for the partnership debts. So she is a partner. Partners are normally jointly and severally liable. The fact that she is a sleeping partner is irrelevant. The law does not differentiate between a partner who is actively involved and a partner who isn't. So if you are a partner in an organisation, you have a certain duty to be aware, engaged and understanding the nature of the business that's going on. So Claire cannot escape liability by merit of the fact she's a sleeping partner. The second task looks at Dan. So Dan has retired. So what does that mean? Well, the situation here is that both Greg and Hugh, so the two customers, both believed that Dan was still a partner for the business. So it's important that if somebody is retiring from a partnership, they need to make sure that people are aware that they have retired. So you can remove your liability, but you have to notify people. So it is not true that there's any time limit on this. So the fact that it was more than 6 months is irrelevant. He is liable for any debts or obligations incurred prior to retirement. The word here, though, only, that makes that statement incorrect. So the act of retiring does not relinquish Dan of responsibility. So his liability does not cease on retirement. That leaves us by process of elimination. It must be the fourth option. He remains liable to new customers who knew he was a member of the partnership unless he declared his withdrawal. So the key factor to consider here: does the customer, does the party to the contract reasonably believe Dan to be a partner? Well, Dan was a partner. And no attempt appears to have been made to correct that understanding in the light of his retirement. So yes, he would remain liable to new customers unless he declared his withdrawal. So if you are retiring from a partnership, then you would expect there to be a notification that goes out to customers and suppliers to say, I am retiring, I am no longer a partner. I know that I have been in the past, but from this date onwards, you should not treat me as a partner. And if you don't make that communication, then you can find yourself still liable. Therefore, for task 3, from whom can Greg claim the outstanding debt? Well, we've got a choice of Claire, Dan, and Eve. Well, Eve is the person who entered into the contract, so she must be liable. Claire is a sleeping partner, but we've said the fact that she was a sleeping partner doesn't remove her liability. That was in task 1, so it must be Claire and Eve. And then with regard to Dan, well, Greg is an existing long-standing customer. He still believes that Dan was a partner, so obviously nobody's notified him that they're not. Therefore, all 3 of them remain liable: Eve, Dan, and Claire. This question looks at the role of company directors. And the scenario we have here is Jer was disqualified from acting as a director because he was engaging in fraudulent trading. So he's been barred for a period of 10 years. The problem is he wants to continue to pursue his fraudulent business. He wants to try and get round the disqualification order. So what does he do? He arranges for his accountant, Kim, to run the business, but specifically on his instructions. Now, although Kim took no shares in the company and was never officially appointed as a director, he nonetheless assumed the title of managing director. So the first task asks us to categorise Jer and Kim. What sort of director are they? So let's just go through the definitions first then. We can differentiate between a de facto director and a de jure director. So a de facto director is one that is not formally appointed, whereas the de jure director is one that is formally appointed. Well, we can see from the scenario that neither director has been formally appointed. So Jer is trying to avoid the consequences of his disqualification order. So we know that he wasn't formally appointed, and it says Kim was never officially appointed. So that option is not going to be relevant for either. Now, the other definitions we've got: a non-executive director has no day-to-day role. So we contrast an executive director who is involved in specific roles on the day-to-day management of the business with the non-executive who contribute towards things like corporate governance and independent views and things like that. Now, again, looking at this, while Kim is running the business, Jer is giving instructions on running the business. Neither of those can be said to fall under the category of a non-executive director. The fourth definition here then, the shadow director. The shadow director is somebody whose instructions are followed even though they are not a formal director. So in this situation, Kim is the managing director. The instruction is that Kim is expected to follow Jer's instructions. Therefore, Jer is a shadow director. Jer is acting from the shadows, trying to hide away, but is still a director by virtue of the fact that he is influencing, instructing the other directors. Now that leaves us with Kim. Kim is following the instructions, not giving them. So Kim is not a shadow director. That means that we categorise Kim as a de facto director. Although not formally appointed, Kim is still acting as a director and is still recognised as a director. The final task here refers to the role of non-executive directors. So what we said about non-executive directors is that they attend board meetings but do not have a day-to-day role in the running of the business. So going through these options one by one, they attend but do not vote at meetings. No, a non-executive director has the same voting rights as an executive director. So that bit makes it wrong. They owe fiduciary duties. Fiduciary duty, a duty of good intentions. That is absolutely true. As with all directors, they owe a fiduciary duty to the company. They are expected to act in the company's best interest. They have contracts of employment with the company. They may or may not. They may have contracts. The key to this is in terms of employment, they aren't technically employees of the company. So there may be a contract appointing them as non-executive directors, but they are not technically employees. And as we've established, they are not involved in the day-to-day running of the company. So therefore, the answer is the second one. They owe fiduciary duties to the company. Which of the following is indicated by the abbreviation LTD at the end of a company name? Well, LTD stands for a private limited company. And we distinguish between LTD and PLC, which of course is a public limited company. So in terms of the options open to us, shares are freely transferable on a stock exchange. To transfer your shares on a stock exchange, you must be a public limited company. So the letters LTD do not qualify you to freely transfer your shares on the stock exchange. The shares may not be offered to the public. That is the case with a private limited company. However, those shares in the private limited company are transferable. So that final statement is not correct. In other words, with a private limited company, the shares can be bought and sold. They can be transferred, but unlike a PLC, I cannot offer them for sale to the public at large, for example, through a stock exchange. So the answer to this is the shares may not be offered to the public. In the context of the English legal system, which of the following defines the ratio decidendi of a judgment? Well, ratio decidendi is Latin. It translates as the reason for the decision that was made. In other words, it's the justification that the courts use in applying the law. So it is the first answer here, the legal reason for deciding the case. So the judge says, well, on this basis, the ruling is X. We base the ruling on the law, and the heart of that ruling is the ratio decidendi. Now, that ratio decidendi may be, and may well be, applied in the future, but that's not in the minds of the judges when they're making this decision. So the focus is very much on the current case. The decision in a previous case we refer to as judicial precedent. And the facts of the case, some of those facts may inform the decision, but many of the facts are obiter dicta, in other words, said by the way. So you might think about a situation where a ruling has been made on contract law. There may be all sorts of facts about the contract and what paper it was written on and whether they were buying or selling light bulbs or books or something else. Those are all facts, but they're not relevant to the heart of the legal decision. They're not relevant to ratio decidendi. They are obiter dicta. They are facts made by the way. It is not unusual for some company investments to carry cumulative dividend rights. So which of the statements about cumulative dividend rights is correct? Well, a cumulative dividend is one that is fixed, that builds up over time, and we often see that relating to preference shares. So those cumulative dividends are paid when there are profits available for that purpose. So if the profits are generated, the dividend is paid. If the profits are not generated, then the dividend effectively accrues. It builds up over time. Dividends are not paid out of capital. There are very strict rules about how dividends can be paid. They're normally paid out of retained earnings. You would not expect them to pay out of capital. You would not pay them in the form of a bonus issue. A bonus issue is an issue of additional shares in line with existing holding. That's not what a cumulative dividend share provides. Remember, the right is to a dividend rather than more shares. And the statement they are not paid until profits reach a certain percentage. Again, that's not the case. The criteria that has to adhere to is that the profits are available. So once the profits are available, then they can be used. You don't have to reach a certain percentage of profit in order to pay it out. This question looks at acceptance within the law of contract, specifically on the UN Convention on Contracts for the International Sale of Goods. So the scenario that we've got here is we've got a buyer and a seller who enter into a contract. Now, the question arises, well, when does acceptance take place? Because what happens, one party will make the offer, the other party accepts the offer, and assuming that there is consideration, assuming that there is intention to create legal relations, the contract becomes binding on acceptance. So it's very important that we know when was the contract accepted. Now that becomes more of a problem on an international basis because the distance between the buyer and the seller may be quite significant. So the UN Convention is designed to standardise, to clarify the law in this context. And in terms of your textbook answer, the textbook answer is acceptance takes place when it reaches the offeror. However, that has to be within a reasonable time. So, classic example, I've received an offer through the post. I want to accept that offer, so I accept the offer and I send it back maybe via a courier or something like that. The acceptance does not take place until it reaches the offeror, the person who made the offer. assuming that that's within a reasonable time. The second option here, when the offeror, the person making the offer, acknowledges receipt of the written acceptance, there is no obligation to acknowledge receipt. So that is not required for acceptance to exist. When it is properly posted, this refers to the postal rules that applies within some jurisdictions in the UK and to some extent within the US. That is not the case under the UN Convention. What the postal rules say is that acceptance takes place when the item is post, not when it's received. That is not applicable here. So under the UN Convention on Contracts for the International Sale of Goods, acceptance takes place when it reaches the offeror within a reasonable time. Which of the following is the primary source of law in a civil law system? So a civil law system, by definition, is one that is based on codes or rules or a legislative framework. In other words, a written set of rules. And we can contrast that with common law, which uses a body of case law, in other words, coming from the courts. So on that basis, the primary source of law in a civil law system is the set of codes. The common law system is more likely to be based on the courts and judicial precedent. Customary law are based on patterns of behaviour that are accepted within that social setting. So, for example, you might have a society that says theft or killing is wrong. It might not be written formally in a legislative framework. It might not have been applied through judicial precedent, but it's an accepted custom. In the context of Sharia law, which of the following is a fundamental source of law? So Sharia law, a very specific type of Islamic law, which is examinable across this paper. So it's important that you are comfortable with the definitions here. So in terms of the academic answer to this question, the fundamental source of law for Sharia law is the Quran. So the Quran is Islam's central religious text. That is the fundamental source. Sharia law tends not to place as much emphasis on court judgments, so this idea of precedent. In terms of your definitions, fiqh is a development and interpretation of the Quran. Now, this interpretation is done by experts in their field, but it's recognised that fiqh is changeable. So whereas the Quran is constant and unchangeable, fiqh, the interpretation of the Quran, may change. And then the fourth area here, the hadith. These are traditions around the Prophet Muhammad, which is a source of guidance. But again, the key question in this here is the fundamental source. The fundamental source for Sharia law, we keep coming back to the Quran. Ari was successful in an international arbitration against Bow. Now, this international action was held in Bow's country, but Ari is concerned that he will not be able to enforce the award in his domestic courts. So we've got an issue here of international trading here and international arbitration. Which of the following does not provide a ground for a court to refuse to enforce an arbitration agreement under Article 36 of the United Nations Commission on International Trade Law, Model Law on Arbitration? Well, the United Nations Commission on International Trade Law is a subsidiary body of the UN General Assembly, and it's all there to facilitate, to support international trade and investment. As a result of which, there are very limited grounds for a court to use this article to refuse to enforce an arbitration. In other words, the whole reason this commission exists is to facilitate, not obstruct, international arbitration. So the only grounds that a court could use using this article would be if for some reason the arbitration agreement expressly provided that no appeal could be made to a court. So, for example, there could be a situation where the arbitrators hear the case, they make a ruling, but there are certain factors that mean that the ruling would not be appropriate to apply in certain countries or certain situations or whatever, in which case there would need to be an express provision to that effect. All of the other factors to do with it would be contrary to public policy, there's an issue with the law of the country, the agreement isn't valid under the law of the country. So any local legal issues are not relevant here. The UN Commission is not going to allow that to be used as a defence to avoid that. So it must be that the arbitration agreement expressly provided that no appeal could be made to a court. ICC Incoterms establish risk and responsibilities in relation to international contracts. Which of the following is the buyer responsible for in a CIF contract? Now, there's quite a lot of terminology here, so let's unpack the terminology first. ICC Incoterms are global standards for the delivery of goods, and these standards have been brought together by the International Chamber of Commerce. So it's our point of reference there around risk and responsibilities. Now, within these terms, there are two types of contract. We have CIF, which stands for Cost Insurance Freight, and we have FOB, which stands for Free on Board. So, which of the following is the buyer responsible for in a CIF, Cost Insurance Freight contract? Well, the principle of a CIF agreement is that it's the seller who pays the costs, who assumes liability until the goods reach the port of destination chosen by the buyer. So with CIF, it's the seller's responsibility to get those goods to the port that the buyer wants. As a result of that, the seller has to make sure that they have arranged an export license and that they have sufficient insurance. The only thing that the buyer has to do that's on this list is to arrange for an import license if required. So if they have to get permission for these goods to come in, that's the buyer's responsibility under CIF. The rest is for the seller. Mo has a significant holding in the shares of Novaco. Now he wishes to use this shareholding to remove Owen from the board of directors, but he's not sure how to do so. So which of the following must be used to remove a director from office? Well, we can do this by process of elimination. Written resolutions are available to private companies, and they remove the need for people to meet face-to-face. However, a written resolution is not permissible in circumstances where there is the removal of a director or auditor. So that one is not acceptable here. To remove Owen, we need an ordinary resolution. So more than 50% of votes in favour. So we don't need a special resolution. A special resolution is 75% or more. However, because this is specifically around the removal of a director, we give special notice. And special notice, normally 21 days notice, which is there to allow the director to prepare a response. So we raise this motion, we want to pass this resolution, we give special notice to the members, to the director has a right of response, we get together in the general meeting, and then we need a more than 50% to pass the ordinary resolution. So therefore, to remove a director, you need an ordinary resolution with special notice. Under the UN Convention on Contracts for the International Sale of Goods, some offers are held to be irrevocable. So which two of the following statements apply to an irrevocable offer? And the technical area here is about the difference between withdrawing and revoking an offer. So we need to select two of these, and what we can see is that two relate to withdrawal and two relate to revocation. So we've got to choose one of each of those. We can't have both of them. So for example, we can't say that an offer can never be withdrawn and can also be withdrawn as long as they're done at the same time. So it's either or in the case of these two. So we need to be clear about the difference between withdrawing an offer and revoking an offer. So withdrawing an offer happens either before or at the same time as the offer arrives with the offeree. Revocation, on the other hand, is when the offer is withdrawn, taken back, but it's done after the offer has arrived with the offeree. So remember, we're talking here about an irrevocable offer. Now, the clue should be in the question. If something is irrevocable, then that means it can never be revoked. So it's irrevocable. We can never revoke the offer. Which means now we need to choose, well, can you withdraw an irrevocable offer? And the answer is yes, you can. As long as it's done at the same time or before the offer reaches the offeree. So there are restrictions on how to withdraw an irrevocable offer, but those are your two criteria. They can never be revoked, so after the offer has arrived, that's it. But you can withdraw the offer as long as you're doing it before or as the offer arrives with the offeree. Which of the following functions is not performed by the World Trade Organization? So just to remind you, the World Trade Organization is an intergovernmental organization. So it's made up of governments around the world, and its role is to enable, to facilitate international trade. And therefore its objective is to try to regulate this insofar as is possible. So what does it do? Well, it does settle disputes between member states. It does review national trade policies, and it does administer trade agreements. So all of these are integral to regulating and facilitating international trade. The thing it doesn't do, it does not get involved with individual cases. That's for the countries involved, the states involved to settle. So individuals with a problem would never go to the World Trade Organization, although countries with a problem would. So if I'm really not happy with the way that the United States or China or Australia or whichever other country is dealing with my country, that's when I go to the WTO, the World Trade Organization. Which of the following is not an actual type of letter of credit? So we've got 4 types of letters of credit listed here. Let's go through them one by one. So we start with the revocable letter of credit. This is when one party can unilaterally alter or withdraw from this agreement. Now these are not very common for the obvious reason that the person, the beneficiary of the letter of credit, is not going to be very happy if they sign an agreement and then the person who's offered the letter says, actually, I can change my mind at any point. But technically, those do exist, so that is not one of the answers. Now, the endorsed letter of credit. You can get endorsements on a letter of credit, so undertakings from the bank or something like that, but that's not an actual type of letter of credit in itself. So in terms of the exam, it's the endorsed letter of credit that is not an actual type. Just for the sake of completeness though, let's carry on and just give the definitions of the other ones. So the revolving letter of credit is designed for when parties are in a long-term relationship with each other. So the revolving letter of credit means instead of having to sign a new letter of credit every time you enter into an agreement, they sort of roll forward for multiple uses on an ongoing basis. And there's normally an expiration date. So we might say, okay, this is the revolving letter of credit for the next 12 months or something like that. The standby letter of credit is effectively an insurance policy. And what this means is that if something goes wrong and the injured party, the party that suffered the loss, has not been able to get compensation in any other way, then you can make this claim from a standby letter of credit. So it's an insurance, it's a sort of security blanket to give the party encouragement to enter into the agreement. It is a recognised type of letter of credit. So in terms of the exam then, the endorsed letter of credit, that is not the actual type. Under Article 35 of the UN Convention on Contracts for the International Sale of Goods, the seller must supply goods of a quality that is fit for purpose. So that's the legal term, it must be fit for purpose. Now, which of the following is not included in terms of quality being fit for purpose. So the first thing to emphasize is when we talk about quality, quality does not mean expensive, exclusive, as it might mean if we talked about sort of quality in traditional marketing context. We're talking here about, does it meet the purpose that it's set out to do? So which of the following is not included as this part of quality? The answer is the first one. Fit for an unusual use not known by the seller. So it is not reasonable for the seller to be held accountable for a use of its product which they simply never expected and never realised. There's a nice practical example of this. There's a cosmetics company called Avon that produced a body lotion. Now, it was discovered informally that this body lotion was especially effective at repelling mosquitoes and insects. As a result of which, a lot of people in Scotland who were going out fishing would buy the Avon body lotion and use it as an insect repellent. Now, Avon never developed the product on that basis. That's not what it was intended to do. There was no scientific research to back it up. And crucially, Avon was not promoting it on that basis. So therefore, if somebody chooses to buy the Avon body lotion and then went back to Avon and said, well, hang on a minute, it doesn't repel insects, Avon's response would quite reasonably be, well, no, we never said it would. It was never intended to. The fact that people might have talked about this happening, that's not our doing. It's not reasonable for us to expect and allow that to happen. However, what you would expect in terms of being fit for purpose is that it's packaged adequately. So if it's being delivered, if I'm having a crystal vase delivered, it's entirely reasonable to expect that it's properly packaged so that it doesn't get damaged. That it's allowed to be used for an unusual use if it's suggested by a sample of the product. So let's return to the Avon perspective. Imagine now that Avon has recognised that lots of people are buying this as an insect repellent when they're going out fishing. And so they adopt a marketing campaign and promote this lotion in fishing shops. Angling shops, where everyone's going there buying their rods, their lines, all of their fishing equipment. And there is this big Avon promotion with body lotion linked to fishing, and maybe it's something like, feel your best when you're out fishing, all of those sorts of things. Now, Avon has not explicitly sold this as an insect repellent, but the way that the product has been promoted, it might be unusual, but it's suggested. In other words, it seems to be known by the seller and the seller is trying to play off it. In which case, if the seller knows and is trying to play off it, then actually that would be then deemed as being part of what's required fit for purpose. And obviously, if the goods are being used as you would normally use them, as a body lotion, you would absolutely expect that it works as a body lotion. So the only one of these that is not required in terms of quality that's fit for purpose is the unusual use not known by the seller. Which of the following parties normally issues a letter of comfort? Well, let's just remind ourselves what a letter of comfort is. An assurance that a third party's contract with a certain party will be met. So the scenario here is we've got two parties, A and B, and let's say that A is worried about B's ability to pay. So in that situation, we would get a letter of comfort provided to A to give them confidence to address their concerns. So who would issue such a letter? Well, would the bank of a company in financial difficulty issue such a letter? Probably not, because the company is in financial difficulty. So as a bank, I'm not sure I can provide that level of comfort. As a bank, I'm going to be concerned. I'm going to be thinking about what happens if this organisation, this party can't pay. So we know it's not that one. The third one, a company in financial difficulty. Well, B, in this case, the party that A is worried about, a letter of comfort from them is not really going to be very meaningful. All that's saying is B is making a promise that, that they can be relied upon, they can be trusted. But of course, B has an obvious vested interest in that. So a letter of comfort from B is really not very meaningful. On the other hand, if B is in financial difficulty and the parent company provides a letter of comfort, now actually that is a little bit more meaningful, because the parent company is not the organisation in difficulty. They're providing an assurance which is more likely to be meaningful. So in this situation, the answer is the parent company of a company in financial difficulties. Which of the following statements relating to limited liability partnerships is correct? So remember, a limited liability partnership is halfway between a partnership and a limited company. So with a limited liability partnership, there is no obligation to have at least one unlimited member. So a partnership does have unlimited liability, but by definition, a limited liability partnership, you do not have to have at least one unlimited member. There is no maximum on the number of members for any sort of partnership or company. However, to be a partnership, by definition, you must have a minimum of 2 members. So there must be somebody and then somebody else who is a partner. You cannot be a sole partner. So that's the answer. They must have a minimum of 2 members. If there is only 1 member, then you can either be a sole trader, which of course has unlimited liability, or if you've got 1 member, you would look to set up a limited company if you wanted to limit your liability. Which of the following business forms does the use of the abbreviation LTD after the name of a business indicate? So you need to be very familiar with the different abbreviations that are used for different types of businesses. So LTD is a private limited company. So the company's the liability of the members of the company is limited. It is a private company in the sense that it is not selling its shares to the public, for example, on an exchange. A limited partnership and a limited liability partnership would have the abbreviations LP for a limited partnership and LLP for a limited liability partnership. Which of the following describes the result for any agreement subject to a fundamental breach of contract under the UN Convention on Contracts for the International Sale of Goods? So when we talk about a fundamental breach, we're talking about something severe. We're talking about that this fundamentally undermines the contract. So it's not something minor where there's a minor substitution. For example, let's say I'm building a house for you and I end up substituting the type of concrete, which is not exactly the same as the part specified, but it's very similar. That would not be a fundamental breach. If, on the other hand, I built the house out of wood instead of brick, then that's a pretty severe situation. So if there has been a fundamental breach of contract, then what does that mean? It means that the injured party has the right, but not the obligation, to avoid the contract. So with this building example, I'm expecting my house to be built out of bricks. I turn up at the building site and I see this whole thing built out of wood. If I'm really upset, if this is not what I want at all, then I have the right to avoid the contract and say, that's it, you've not built what I've asked for, I don't want it, forget about it. But it's not an obligation. So maybe I turn up and I look at it and think, my goodness, that wooden house is amazing. It's so much better than I thought it would be. I love it. I love it even more than I'd love the brick house. Well, if I still like it, I can retain the contract. Crucially, this is my decision as the wronged party, not the builder's decision as the person who breached the contract. So, on that basis, the agreement is enforceable, so it's not unenforceable. The agreement is avoidable. It's the able bit that's really important. It's not void, but it can be voided by the injured party. Section 122 of the UK Insolvency Act 1986 specifically provides a distinct ground for applying to have a company wound up on the grounds that it is just and equitable to do so. So in the context of this, equitable means fair, so it is just and fair to do so. Now, which of the following parties may petition to have a company compulsorily wound up on the basis that it is just and equitable to do so? Well, there are a number of ways in which stakeholders, parties, can apply to the courts for a company to be liquidated. But just and equitable is a very specific one. It applies uniquely to the shareholders of the company. It's quite a broad term, and it's there in order to protect shareholders, to give them that safety net that says, look, something really bad has happened here, something really problematic has happened, and for whatever reason, there's a determination to keep the company going, and we don't think that's right. So you'll have seen case law. Maybe there is a total breakdown in the members or directors of the company. Maybe the main object, the whole reason the organisation was set up, has failed or become impossible. So, for example, let's say that I'm a company that organises fox hunting in the United Kingdom. fox hunting with hounds. Well, if that becomes illegal, as it did in the United Kingdom, then any organisation arranging fox hunts becomes illegal. If the company does not wind itself up, then a member may apply to the courts and say, look, the whole reason this company exists is now non-existent. The other shareholders, for whatever reason, aren't following this. We ask the courts to intervene. Now, of course, creditors, other stakeholders, they do have the right to apply to the courts for a company to be wound up, but that would normally be liquidation. So, for example, the creditors of the company could apply to the courts for the company to be liquidated on the grounds that it can't pay its debts, but that would not be under the just and equitable winding up principle. In this section B question, we've got a contract law issue. So Axelco, a German company, operates a business making specialist machinery for the international car manufacturing industry. In 2011, Axel entered into an agreement with Bold Co., a Danish manufacturer, to build a specific piece of machinery to Bold's specification. So we have a contract between A and B. The contract price was $7 million in return for this specific piece of machinery. However, just before the completion of the machinery, B told A that due to the downturn in the world economy, it no longer needed the machinery. Now, A has already spent $5 million in producing the machinery. So starts a legal action against Bold for breach of contract. However, in the week before the case was due to be decided in court, A sold the machine to a new client for exactly the same amount of money that it would have received from Bold. So they sold that for $7 million. It may be assumed that the UN Convention on Contracts for the International Sale of Goods applies. In task 1 then, which two of the following statements explain the purposes of awarding damages for breach of contract? So remember that a case for breach of contract is a civil as opposed to a criminal case. And the objective, therefore, of this is to compensate the innocent party for any financial loss. So in this case, Axel A has entered into the contract. They've done the work. They've incurred the costs. If they suffer a financial loss, then they have a right to compensation. In terms of the overall objective, it is about putting the parties in the position they would have been in had the contract been performed. It is not the intention of damages to put parties back in the position they would have been in before the contract was formed. Now, that might be relevant to you if you are ever in a retail situation where you've bought something, and obviously purchasing something in a shop is a contract, and you're not happy with the product. Often what the retailer says is, well, I'll give you a refund. Now, you have the right to accept that, but you also often have the right to say, actually, no, I don't want a refund. I want you to supply the product that you undertook to supply me with. And because this is civil as opposed to criminal law, there is no punishment involved here. There are some situations where we see punitive damages, but that's not in the UN Convention on Contracts for the international sale of goods. So punitive damages are very much a niche area. You see it a little bit more in the United States, but generally speaking, that is not the intention of awarding damages for breach of contract. Task 2, which two of the following statements in relation to the duty to mitigate losses are correct? So when we talk about mitigating losses, this is the action taken by the injured party. So if in this situation A is suffering a loss as a result of B's breach of contract, A still has a duty to mitigate their losses. What that means is the duty lies with the party who suffers the breach, in this case Axel or A. It does not lie with the party who is in breach, in this case party B. It does not increase damages, it reduces damages. The word mitigation, to reduce your losses. So as the injured party, the party that suffered the breach, they have a duty to minimise their losses through their actions, and that will therefore reduce the damages that are incurred. The third and final task then, what level of damages can Axel claim for breach of contract? Well, we've established already that Axel has a duty to mitigate their losses. And we've established that Axel has sold the machine for the price they would have received from B. In other words, the fact that the money that they've got in hasn't come from Bold doesn't matter. A has not suffered any financial loss. They expected to sell the machine for $7 million. They did sell the machine for $7 million. Therefore, there is no loss. The answer is 0. This question looks at fraudulent and wrongful trading. So the scenario here, we've got two directors, Fran and Graham, F and G. They registered a private limited company, and each of them is a director. Now the company made a small profit in the first year, second year of trading it made a loss. At this point, Fran said he wanted the company to cease trading. Graham was insistent that they should continue. So what happens, Graham continues and Fran takes less of a part in the day-to-day management of the company. However, he does remain as a company director. What then happens? Well, Graham then falsifies the accounts for a period of 3 years to disguise the continued losses. Eventually, it becomes obvious there's no alternative. We're going to go into liquidation and there are debts. So the first task is about wrongful and fraudulent trading. What type of action is taken? Is this civil, criminal, or both? So just as a reminder, civil action, the objective is to compensate the injured party, whereas criminal action, the objective is to punish the wrongdoer. Now, in terms of our definitions of fraudulent and wrongful trading, so both of these fall under the Insolvency Act 1986, and fraudulent trading is when a director or anybody else carries on trade with the intention of defrauding creditors. Wrongful trading, on the other hand, takes place when a director or a shadow director should reasonably have known that there was a problem with the company's liquidity. Now note therefore the difference. Fraudulent trading, there is intention. Wrongful trading, there doesn't have to show intention, just reasonableness. Now, in terms of what does this mean in terms of civil and criminal liability? So fraudulent trading can be a civil case, but it can also be criminal. So it's both civil and criminal. So somebody, an injured party, a creditor, can take action against the directors, but the state can also take criminal action against the directors to punish them. whereas wrongful trading is a civil offence only, and you would not normally expect to be prosecuted and punished for wrongful trading. So for task 2, we've already talked about the definitions of fraudulent and wrongful trading under the Insolvency Act. So what is the situation here? Well, which applies? In the case of Fran, well, Fran was not actively involved in running the company. Fran was taking less of a part of the day-to-day management. There's no evidence that Fran was deliberately committing fraud. However, as a company director, he should reasonably have been aware of this. Stepping back and being ignorant is not a valid defence. The fact that the company had been struggling, the fact that Fran thought the company should be wound up and allowed it to continue means that you could look at a charge of wrongful trading for Fran. Graham, on the other hand, is different. Graham, there is a clear intention because he's falsified the accounts. That falsification makes this fraudulent trading. A written ordinary resolution requires the approval of which of the following? So just as a reminder, a written resolution is limited to private companies, and it allows the members to pass a resolution without actually having to meet in the same place. Having said that, the fact that it's a written resolution does not change the level of voting required. So I'm going to put that bit in brackets. So we're talking about an ordinary resolution that happens to be passed in writing. So an ordinary resolution requires more than 50% of those actually voting. So it's no different to an ordinary resolution in a meeting. Now, just be aware of a couple of tricks that you might see in the exam. The first is that it's more than 50% of those actually voting, not those entitled to vote. So if you have 100 shareholders and only 10 of them turn up, you can pass a resolution with 6 votes. Just be aware as well that it is more than 50%. In other words, 50% cannot pass an ordinary resolution. So if you have 2 shareholders, you need both shareholders to vote in favour of a resolution in order to pass it, assuming they're equal shareholders. One by themselves is 50%. 50% is not enough to pass an ordinary resolution. Which of the following is not a form of alternative dispute resolution? Well, an alternative dispute resolution is when we have 2 parties in a state of disagreement and they make a decision not to go down the formal legal approach. And the reason for that is often to do with the cost, the time and the complexity of a legal case. So the alternative dispute resolution seeks to find a resolution between this disagreement without recourse to the full legal system. And generally speaking, there are 3 types of alternative dispute resolution. One of them is mediation. So when 2 parties go to mediation, an independent party suggests a solution. So there's a specific dispute, the 2 parties go to the mediator tries to find common ground, and they will suggest a solution. There is no obligation under mediation to adopt that solution. Under arbitration, however, the two parties agree before the start of the ADR, the Alternative Dispute Resolution, that they will be bound by the recommendation. But in the case of mediation, the independent party suggests a solution, no obligation for either party to follow it. I'm going to go on to conciliation next. This is when the independent party helps the two sides to find their own solution. So conciliation, sometimes described a bit like marriage guidance. Yeah, you bring the two parties into the room, you try to get them to see things from the other person's point of view, you try to encourage them to find their own solution. The difference, therefore, between mediation and conciliation is that the mediator will actively suggest a solution that they think is fair, and that with the conciliator will not suggest a solution. That leaves us with harmonisation. That is not a form of alternative dispute resolution. Harmonisation in a legal context is when countries, states have to bring their own legislation into harmony with wider standards. So a classic example of this would be the European Union has EU-wide legally binding standards, and it's important that those rules are harmonised, standardised across all of the states. But that is not a form of ADR, so the answer is harmonisation. Which two of the following are recognised mechanisms for international payment? So we start with a letter of comfort, which is an assurance about a debt. So normally given to a bank by a third party. The important thing about a letter of comfort is it is not a legal guarantee. Yeah. So an assurance is providing some comfort, as the term suggests, but it's not a guarantee. So that is not a recognised mechanism for an international payment. A letter of credit, on the other hand, is a guarantee for a payment. So normally this is issued by one bank to another bank, and it's basically guaranteeing that the bank account holder is able to pay, will pay under sort of specified conditions. So that is a recognised mechanism. It provides that guarantee that the seller is looking for. A bill of exchange is a promissory note. It is a promise. It's similar to a letter of credit. The difference here, though, it's normally from an individual rather than a bank, but it's an order which requires the person to make a specified payment. So that is also a recognised mechanism for international payment. A bill of lading, our fourth option here, is simply a receipt. It's a receipt given by the transporter. So, for example, the captain of a ship, it's a receipt that's handed over in return for the goods that are being handed over. So, two recognised mechanisms for international payment, the letter of credit and the bill of exchange. This question looks at Section 122 of the Insolvency Act 1986. And the question here is, which of the following cannot petition for the compulsory winding up of a company on the grounds of insolvency under the Insolvency Act? Well, under Section 122, the Board of Directors, they can petition for the winding up of the company on the grounds that it's insolvent, as can the company's creditors, as can the Secretary of State. So the Secretary of State acts as sort of an overall monitor, an overall reviewer to make sure that things are happening as they should. The Secretary of State can submit a petition. Of course, submitting a petition does not mean that the company is automatically wound up. This is only a petition, and then the courts will decide whether or not to wind the company up. Now, that means, therefore, that the members of the company cannot petition for the compulsory winding up of a company on the grounds of insolvency. There are options that the members of the company have. They can petition the courts for the winding up of the company. They can petition on the grounds that it is just and equitable to do so. In other words, the members of the company don't have to show insolvency. They have to show that actually it's just and equitable, it's fair to do so. So because this question is specifically around insolvency, the members of the company cannot petition on the grounds of insolvency, so therefore that is the answer.